Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye. Dimple says, I saw my rheumatologist yesterday, explained my situation to her, and she is supportive and believes that I have a good case for SSDI. Good for her. I wish she was a lawyer. I know she doesn't have any say in approval, but glad she's on board. Absolutely. Just as a more of a open share for everybody else, when you have a doctor who obviously doesn't know the rules and they screw up notoriously, which is why I always say don't ask them for a letter, because they're going to say, there's a 90% chance they're going to say something that inadvertently shoots your case down, because they don't know those little fine little needle threading you have to do, particularly like if you're dealing with a grid situation that you could use. They screw those up all the time. I guess it's kind of like that little information. Little knowledge is a dangerous thing. And so they need to stick to their pay grade unless they are willing to actually speak to the attorney, which usually they're not. Like Dimple's saying, if they are on board, generally, that means they have good intentions. And if that's true, and she's not just blowing smoke up your rear side, Dimple, then it's very possible that someone like that is willing to answer some very tailored questions on paper. That could be direct evidence in addition to her hopefully well-articulated medical records that really show the limitations. The more the doctors actually describe the person as a real person with their limitations, the better the records are for proving these legal needs in life, like such as SSD qualification and SSI, which has the same disability definition. But so many, we talked about this before, the poor record keeping, the automated computer systems that default to within normal limits, unless you specifically, tell them that day, I have this complaint, which really, it should be a little more broader than that. Like, what's your problems generally? It's not just today. It's like, what was going on last week that comes up every 4 days? Or you have to not have a lazy recorder, which could be a medical assistant or the doctor or the nurse or whoever, who knows. I harp on this all the time because I read thousands of pages of medical records every week. And of course, in the throes of it right now with that situation I was discussing, and I see how poor it is. So don't even get me started, Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Good afternoon. I was going to address a question that I get a lot, and even online I see it all the time, particularly for a pro se person. Should you be asking your doctor for a letter to the SSA? I really think it's it has a lot of risk to it, all right? If your doctor's recordings in your medical records are really thorough and address not just your diagnoses, but the things that are going on with you in terms of symptoms and limitations at home and all that kind of stuff, then there really wouldn't be a need for a letter. And the bigger reason, though, is that if a doctor wants to send a letter, off the cuff about you, trying to help you, obviously thinks you have, some sort of disability or limitations or whatever, what we tend to often see is a well-meaning doctor will include some verbiage that he or she does not realize is indicative of not falling on the side of disabled under the SSA policy rules. So they might say, Don can only, I don't expect him to be able to stand or walk more than 4 hours in an 8-hour day. Well, guess what? For many, many people, given their vocational profile or work history and everything else that goes into a decision as to whether you can do your old work, either as you performed it or as it's generally performing the economy, or any other of the 12,000 jobs out there or more, according to the SSA. So if saying, the doctor's thinking 4 hours out of 8 is all he can walk, when a regular person can walk from, morning till night, an unimpaired person, that's significant limitation. And it is. However, it does not necessarily eliminate all jobs from being performed, particularly some sit-down jobs, for instance. So them saying that could actually be the nail in the coffin of your case in a bad way. I mean, you won't be able to be found disabled potentially, depending on what your vocational profile is. So if your doctor isn't aware of that, and he is maybe not, you believe you can't even be on your feet 4 hours. So now he's thinking that's a lot, but he doesn't actually know what you do at home and how limited you are. All of this can really be worked against you. So I really kind of implore people to not just ask your doctor who is not well versed in Social Security laws, and there's a ton of them they would have to know, and all the vocational principles. Asking them to do a letter off the cuff oftentimes can be more hurtful than not. Particularly if, and then other times the letter just, people get a letter off the cuff and the doctor just confirms their diagnosis and how long they've been treating them. Well, that's evident from the records already, because diagnosis is always in there. He has to have it in order to get insurance payments and everything else. And the dates of treatment are always in there. So it's not necessarily going to be helpful to you. I know it makes you maybe feel like it's going to be bettering your case, but a lot of times, like I said, something very limiting that the doctor thinks it's extremely limiting, but the doctor doesn't understand that that limitation actually works with certain jobs, he can be really hurting your case. We do ask for medical source statements, and that's what we refer to them as. But when we do them, they are after the plethora of hopeful medical evidence is in, including from that doctor and all the other doctors. And if there is something that the doctor might be willing to confirm that is not really clear from his records, but it's not disputed in his records, because his records have to support his medical source opinion at some point, going down the road. So when you get that letter in. So if his letter is not supported by his own records, certainly if it's not supported by other records, and if, gosh forbid, it's inconsistent with other medical evidence in the record, it's not going to be well taken, and it might just be utterly disregarded. And then there's a risk also of, if they find the doctor lacking in credibility because of this letter, will they also then find his records to not be something to rely upon a lot when making a decision as to how limited you are? So there's a variety of risks. And when we want to get a statement from a doctor, I usually like the doctor to know a little bit about the law that he's referring to. So we have a little guidance page where he can know what certain definitions mean, so that he's not just speaking off the cuff and using language that means not disabled for you. Okay. So we try to make it clear that this word is going to mean that you can do this 2/3 of a workday. This word means only 1/3 of a workday, So without giving him some kind of narrowly defined a question, so that he's not answering questions on things he doesn't even treat you for, or if the answer he's going to give because it's accurate is not one that's going to help your case, I don't want to ask him that question. I want to ask him the very limited questions that would be where the answers we know support disabled, what we know to exist from the rest of the file and from you supports disabled, and can't really be twisted in a way that would otherwise be able to hurt you. So it's kind of like threading a little needle, and we don't want to give the doctor, sometimes people throw out these 9-page requests for, it's like an RFC questionnaire that you can get online, and the doctors are just going to say no anyway. And then if they do answer it, they could be answering about, can she use foot pedals? And they have no idea, because they treat you for your arm and they're trying to be helpful. So they answer something and it's contradictory to the other evidence, and now credibility is shot. So it's really something you got to be really careful with. I think it's got to be done individually based on your records, and the records have to therefore be full. So it's not something you're really necessarily going to do in the first few months of an application. And I'll go even further to say most doctors won't even do them. But there are some that are definitely caring about their patients and know the patient is seriously screwed up and will do them. So they're worth their weight in gold. Some will also charge you, some won't charge you. Some that charge you will be reasonable, some that charge you will be far from reasonable. Because really what you're just asking them, you don't want them to evaluate you and give you an exam. They've been doing that every time you visit them. We're asking them for their opinion on their patient that they've been treating. So that is a whole nother issue as to the doctors that won't help their patients by at least providing actual information that they have and that they're paid to have, yet then they're not sharing it. But in terms of the danger of asking a well-meaning doctor for a letter without actually honing in carefully and making sure he knows what things you want to know about, what different definitions are. So if he's going to say someone could do something occasionally, he needs to know what that means. Anyway, that's the answer that I would give when my clients say, should I get a letter from so-and-so? I'm like, no. If there's something specific that can be helpful, we will ask it of him. And it would only be if he's not completely contradicting it already in his records. So, you know, you give him contradictory or he gives contradictory answers, now everything that he has said is shot. So, you know, you got to be very careful what you wish for, because you might just get it and it might not be what you wanted. All right. So I suggest no letters, since I don't think you're going to know how to do it. It's not something that happens overnight, and it takes me hours to put it together for a client. So, and that's when I know everything that I know their file and I know the law that needs to be applied, but you're always trying to carefully thread that needle and make sure you're not asking the doctor too many things that he's going to be like, I'm not filling this out. You're asking for 10 pages of stuff. I keep mine to 1 page, and each question is only those that would be relevant to the case. And you're not going to know what's relevant to the case. I don't think you are. It's just not. I haven't seen it yet, actually, in a client ever. All right. I will chat with you later. Bye, guys.